Good morning all. Today we're in the matter of a case management conference for CFI 007-2018. The claimant is represented by King & Wood Mailsons Mina LLP, lead counsel Tim Taylor QC. Assisting is Joanne Strain and Dixon Deng. Defendants is represented by Al-Tamimi and Company. Lead counsel is Sharif Shivji. Assisting is Rita Jaballa and Diego Carmona.
Good morning, Alex. This is a case management conference and I appear for the claimant. After quite a lot of correspondence, there is in fact very little in the sheet to be determined. The case management directions, which Your Excellency will be invited to make, are substantially agreed. I can take Your Excellency to there's some differences between the parties on these issues. At the end of the day, even though extensive amendments were initially proposed by the defendants, there is little between the two parties as to the list of issues. I think the key matter is the two key matters. One which may require an application by my learned friend for decision, and the other is just a matter of understanding as to the amendments that have been made to the particulars of claim. It's agreed by both sides that this is a very simple case. Sums of monies were advanced by my claimant to the defendants. One is the defendant's former stepson, and it was married with the son of his ex-wife, and those were used by him for the establishment of the second defendant, which is Duzty's, which has a bar somewhere here in the DIFC. The only real issue is whether these monies are gift, yes or no. We say that they were advanced not as a gift, but to be repaid. Originally, the claim was made purely as a claim in contract, for which one would need to establish some very basic terms. I gave some money, how much, agreed to lend it to you. If there was no date for repayment agreed specifically, then a reasonable demand was to be made. The alternative claim that my clients have sought to introduce by the amended claim is a claim in restitution. Restitution in English law used to be called quasi-contract. It's now called unjust enrichment, and its equivalent in DIFC law is to be found in the law of damages and remedies. The only difference is this: a defence in gift, if it is successful, will defeat either the claim that it was a loan or a claim that the money should be repaid. But you can defeat the claim just made in loan by saying that it's my client's requirement to prove that there was an agreement, it's a claim in contract, whereas in restitution, he simply has to prove that the money was transferred and there was the intention that it would come back and it would be unjust for the defendant to retain it. Very, very simple issues. At the end of the day, in terms of the case memorandum, I can show you, we put a long, complete procedural history. The defendants, for some reason, have deleted some elements of that procedural history. We think that it's not disputed that there's no suggestion that we put anything in there that both sides didn't agree actually happened, directions from the registry, etc. Since we've gone to the effort of putting a complete procedural history, we think that would be better, but at the end of the day, nothing much turns on it. Our list of issues, we prefer, as it came, you can see in the folder that lots of amendments were made, but at the end of the day, if you compare the list of issues now put forward by the defendant, just get my glasses. If you turn your excellency to divider 12, it should be a 12A in your bundle narrative. You see that on the last page of that document, the matters in dispute. Did the claimant enter into a loan agreement orally and by way of conduct with the first and or second defendant? Did the claimant then advance monies to the first and second defendant pursuant to that loan agreement? Just pausing there, there's no real dispute that monies were advanced. There's no real dispute on quantum because there's been an expert report identifying the payments, and my client is voluntarily limiting his claim to an amount that is significantly less than that, so there's no real factual issue. Was it entered into orally and or by way of conduct? What were the express or implied terms of that agreement? Well, that's the loan. That's the way they've expressed it. We'll put the same thing somewhat more shortly, probably. Alternatively, in relation to the monies provided, were they gifts by the claimant? And Mrs. Tourani, the first defendant. Well, that's it. Loan or gift is there. What they have not done is to make any reference explicitly to our claim in restitution. We've put it very succinctly. Are they a gift or are they repairable, either in contract as a loan or by way of restitution? That was our formulation. They just simply put, is the claimant entitled to recover the money from the first or second defendant? I think it would be helpful for the court later on to make it plain, as we have done, that we're making alternative claims. Loan, in contract, restitution, i.e. what used to be called quasi-contract or unjust enrichment is the modern expression. You've then got an additional matter that they have sought to introduce as being an issue, which is, did the claimant treat and refer to the first defendant as his son during his marriage to Mrs. Tourani? Now, we don't think that that is an issue in the strict legal sense, because we do not see that they're making a case that there is a legal difference to be made to the analysis depending whether my client treated the first defendant as his son, whatever that may mean. In family law, there may be particular status issues where what used to be called custody belongs to one parent or another. These days, it's called parental responsibility in modern systems. And if a mother automatically has parental responsibility, if she's married, the mother and father, so her first husband, would all have parental responsibility. If someone else, as a stepfather, is going to take over parental responsibility, they would have to get a parental responsibility order in, for example, the English system. No, as far as we can see, this is just a factual question. What sort of relationship did they have? Well, the judge will hear evidence, and he's going to hear from my client and from the defendant, and he's going to have to make up his mind. Was this money meant to do? Yes or no? Clearly their relationship, whether it was close or they got on, etc., is factually relevant, but it's not an issue in the real legal sense of, is it a question that requires to be determined by the court? So we would say that doesn't need to be in the list of issues. We would prefer our own formulation, which you will find behind divider 11. That's the claimant's proposal for the case memorandum list of issues. paragraph numbers, not page numbers. Material procedural issue, I think we have 25 paragraphs and they've deleted 5. There, I can show you which. And then our list of issues starts at 26. Not an issue that in the period commencing December 2014, certain monies which are subject to this claim were advanced to support the first defendant's business venture, subject to determination on from whom the sums were advanced at whose request, how much and when. The primary issue in the present proceedings is whether the monies are recoverable by the claimant either as a loan repayable by the defendants on reasonable notice or by way of a restitutionary claim, or if the monies were advanced in the form of a gift. Now that, we say, is an absolute summary of the issues as it is. It appears from the correspondence from Tourani's that they may have misunderstood the position with respect to restitution, because they said that they appeared to apprehend that we were introducing a claim in restitution to defeat the defence that it was a gift. Well, that simply doesn't work, because if it was a gift, a claim in restitution would fail, because it wouldn't be unjust enrichment. A gift is a gift. Now that that misunderstanding has been ironed out, I don't really think there's anything much between the parties on that. The order for directions is otherwise agreed. What I suggest, with Your Excellency's permission, I would do, however, is before my learned friend Wright show you that essentially agreed order for directions. My learned friend has an application to make of some kind because his client feels that we have still not adequately particularised our claim. Our position is that we have, but it's his application to make, and if I may, Your Excellency, I'd ask you to invite my learned friend to make that application, and I will respond.
I'm grateful, Your Excellency. I present the defendants in this matter. Your Excellency may have noted from our skeleton argument that this is a dispute between the claimant who was the first defendant's stepfather and the first defendant who was his stepson. And it follows the rather regrettable breakup of the marriage of the claimant and the first defendant's mother. Your Excellency may have noted from the papers that there have been ongoing matrimonial proceedings in the Dubai courts, which have been very hard fought, and the present litigation appears to have sprung out of that dispute. Now, before you today, the claimants have put forward an amended particulars of claim. It's not the point that my learned friend mentioned in any detail, but hopefully he'll deal with it in answer. The court will note that under the rules, the claimant requires permission in order to amend its claim unless consent is given in writing. And if I may, Your Excellency, I'll turn you to the relevant rule. I'm sure it's uncontroversial. It's found in Part 18. Does Your Excellency have a copy of the annotated rules?
Yes, I
The annotated rules.
think that's...
If not, we can hand up a copy. It might
similar to this one, I think.
Perhaps could I hand up this copy, because it's the commentary is quite helpful as well. Although I suspect it's also uncontroversial. So, Your Excellency, if you turn to page 107. We'll start with Rule 18.2. If a statement of case has been served, a party may amend it only, 1, with the written consent of all the other parties, or 2, with the permission of the court. Now, in this case, the claimants have not got the consent of all the other parties, because we say that the pleading is defective, and so, as a result, the claimant needs the permission of the court. And if one turns over leaf, there's some uncontroversial commentary on what the applicable test is when the court deals with permission. And this arises out of a recent decision of His Excellency Justice Shamlan in the Orion matter. And in that case, the court said that the test for whether the court should grant permission under 18.22 is that the amendment should be properly pleaded and have a real prospect of success. And I'd like to emphasise the requirement that the amendment needs to be properly pleaded. Now, Your Excellency, with that background, if I may, I'll take you to the two issues that arise on the pleading. The first issue relates to the claimant's claim that this is a loan agreement. Now, as my learned friend appeared to accept, the burden will be on him to establish that this was a loan. He bears the burden of proof, and his client will need to establish that on the balance of probabilities. The point really revolves around a very short point, which is on the claimant's case, the agreement for a loan was entered either by an oral agreement or by conduct. And so the claimant will need to prove either that the parties entered an agreement orally or that there was some particular conduct which gave rise to an agreement for a loan. Now, the RDC contains mandatory rules when it comes to pleading agreements entered orally and by conduct, and they appear in the RDC at Rules 1741 and 1742. And again, I'll be grateful if Your Excellency could turn that up. This is page 106 of the annotated version I passed up. 17.41. Where a party relies on an oral agreement, the statement of case should set out the contractual words used and state by whom, to whom, when and where they were spoken. And then in relation to the next rule, where a party relies on an agreement by conduct, the statement of case must specify the conduct relied on and state by whom, when and where the acts constituting the conduct were done. Now, Your Excellency, both those rules are mandatory. So if 1741, it says there the statement of case should set out the contractual words used, so that's mandatory. And similarly, 1742, the statement of case must specify. So these rules are not optional for a party bringing these sorts of claims, they are required. And there is a good policy reason why they're required. They're required so that the parties understand precisely the factual issues arising in the case, and they can then ensure when they come to do disclosure and witness statements that they are meeting the case against them. The purpose of these provisions is to narrow the dispute so that the parties are clear what they're arguing about and they don't waste money working on evidence in relation to other irrelevant factors which won't arise properly in the proceedings. Now, these rules are not difficult to comply with. The amount of information required is quite limited. I mean, as one would expect from an oral agreement, it should be easy for a party to say, yes, I entered an agreement with my learned friend, Mr. Taylor QC, on the 14th of May, before court at 9:45, and he said this and I said that, and we agreed. It doesn't have to be a lengthy set of particulars, but the rules require this information to be provided. Now, with that issue defined, perhaps I can just take you briefly to the chronology in this matter. We were served with the claimant's original petitive claim. Now, at that point, my learned friend's firm did not act in this matter, and so no criticism can be made of them for any defect in the petitive claim. But I'd be grateful if the court would turn up the particulars which appear at tab 4 of the bundle. At page 2 of the petitive claim, paragraph 5, the claimant sets out his case for an oral agreement. And I'll be grateful if Your Excellency could read paragraphs 5 and 6.
To read it?
Yes, I'll be grateful.
At the end of 2014.
Your Excellency can read it yourself. I don't need Your Excellency necessarily to read it aloud, but if Your Excellency could just review those paragraphs, I'll be grateful. Now, in my submission, there are a number of deficiencies with this section. First of all, in fact, it doesn't make clear that the agreement was entered orally by conduct. Now, that is something that the claimant has since rectified, and I'll take you to that in a moment. But at this stage, they didn't even deal with that point. And in relation to the oral agreement, they failed to comply with 1741. So there were no reference to the contractual words used, no reference to the persons by whom they were stated and to whom the statements were made. There was no reference to the precise location of where the words were spoken and the date on which they were spoken. And in relation to the agreement by conduct, similar deficiencies. No reference to the conduct relied on and by whom, when it occurred, where it occurred, and the particular acts relied on. Now, as a result of those deficiencies, my client made a request for further information under Part 19 on the 14th of March. And that's a document that previously had been passed, Your Excellency. We'll see that at tab 8 of the bundle. And if Your Excellency turns to the second page of that document, at paragraphs 4 and 5, we ask these questions, and the questions are based on 1741 and 1742. We essentially just say, can you provide the particulars that you were obliged to under those rules? So that's questions 4 and 5. Now we served that on the 14th of March, and we didn't have any response to it. So when we came to file our defence, we also issued an application for an order compelling the claimant to provide that information under Part 19. And Your Excellency granted that order, and we'll find that order at tab 1 of the bundle. Paragraph 2 of the order, Your Excellency required the claimant to file and serve further information in response to our request. So that's paragraph 2. And again, that was a mandatory obligation on the claimant. Your Excellency wasn't giving them the option, Your Excellency was requiring them to provide an answer. Now, at that time, my learned friend's firm came on the record and took over conduct of the matter from the previous solicitors. Now, as I understand it, the previous solicitors are also acting, but the claimant has expanded his team. They asked for more time to comply with the order, and Your Excellency granted them an extension which is found at tab 2. And again, paragraph 2, Your Excellency gave them an extension, but required them to file and serve further information in response to the request. Now, there was no suggestion from the claimant at this point that in any way the request went too far, or that they didn't apply, or that we had sufficient information. And further, the claimant didn't appeal either of Your Excellency's orders. So those orders apply then, and they continue to apply now. Now, on the 22nd of April, which was the last day for compliance, the claimant did purport to file some further information, and that can be found at tab 9 of Your Excellency's bundle. And in relation to this point, this document regrettably is not numbered, but if Your Excellency turns to the third page of the document, you'll find there request 4, which related to Rule 17.41, and the claimant's answer. Does Your Excellency have that page? It's the third page.
Yes.
And then in the middle of the page, they say the reference to 1741 is noted. Now, they don't say materially, and they've never said that 1741 doesn't apply. So they seem to accept that it applies, but they say it's the claimant's position that the POC is adequate for this stage of the proceedings. The request for further information beyond what is provided in the POC relates to evidence which will be provided by the claimant at the appropriate stage of the litigation. And then they go on and they say that the loan agreement was oral, so now this point is introduced. So it's oral and by way of conduct, so obviously 1741 is engaged. And then they provide some very brief particulars. At A, they say that during conversations at the end of 2014, the first defendant made oral request of the claimant for a loan, explain that the purpose of the loan was for the incorporation and the establishment of the second defendant for the purposes of opening and running a restaurant with DIFC. And then they say, in response to those oral requests, the claimant orally agreed to advance money from time to time as would be necessary for the incorporation and establishment of the second defendant, provided that the monies would be repaid by the claimant on reasonable demand. And then they say, given the conversations were nearly 4 years ago, a verbatim record of the words used cannot be provided. Factual evidence of the conversations will be provided by way of witness evidence at the appropriate stage of proceedings. And what they seem to be saying here is they have more information to give in relation to what was said, but they don't propose to do so until they file their witness statements. Now that, plainly, in our submission, doesn't comply with 1741. Firstly, 1741 requires the party to provide contractual words used, or we say at least the gist of the words, and that's because we need to know precisely what the contract was. That's the first point. Second of all, the contractual words used also need to specify the persons by whom they were stated and to whom. And that's particularly important in relation to the second defendant who is accompanied. And then also the precise location where the words were spoken and the date. Now, in relation to the date, all it says here is that this was at the end of 2014, and in relation to the place, it says it was in Dubai. Now, plainly, again, that is unsatisfactory, not what the rule requires. And they should be able to give some particulars as to the place where this conversation took place, and who was there, and at least the gist of what was said. So we say that doesn't comply with 1741, which they seem to accept applies. And then if we go to request 5 on the next page, this is in relation to Rule 1742. And they say the reference to 1741 is noted. I think they mean the reference to 1742. And then they say, again, the same point, they say it's a matter for evidence. And then they go on to say that the loan agreement was oral and by way of conduct. And then the only conduct they seem to rely on is the fact that the money was advanced. And if you have a look at A, the first paragraph refers to the money being advanced. I'd be grateful if Your Excellency could just to read yourself A and B and C, which relate to the advances.
Okay.
So Your Excellency, aside from referring there to the oral agreement, which is obviously part of the oral agreement case, there are no matters relied on for this agreement by conduct, save for the fact that they advanced money. But of course, the advance of money is wholly consistent with our case that this was a gift. Now that this point, I just want to deal with this point about what they say about the evidence, because in our submission, that's based on a fundamental misunderstanding of the difference between evidence and particulars. The obligation on a party in setting out their particulars of claim is to specify the factual matters that they rely on as part of their case. Evidence, of course, is the material that you rely on to prove that allegation. Now, 1741 and 1742 require a party to provide particulars, and that's why it's in the rules. They don't require a party to provide evidence. But even then, this debate about evidence versus particulars is irrelevant because those rules are mandatory, and it seems to be common ground that the rules apply. Now, having received the further information, we wrote to the claimants on the 1st of May, complaining about the state of affairs, and Your Excellency will find that letter tab 15 of the bundle, page 1. We said there in the first paragraph, by order dated the 10th of April, Judicial Officer, Your Excellency, ordered the claimant to provide the information sought in our client's request. And then we said plainly that order would be nugatory if to comply with it was enough for your client to say that it did not consider it was necessary to respond. And we say if the claimant objected, the claimant should have said so and applied to set aside the order. We then say that paragraph 2, that there are various breaches, in particular these points on 1741 and 1742. And then we say we're prepared not to issue a further application if your client agrees to provide draft amendments to petition claim by the 7th of May, which adequately address the matters in question. And we also, I'll just deal with it here, we also make the point about the claimant's reply, because the claimant's reply introduced the claim in restitution. And we say that's not the right way to do it. If you want to introduce a new claim, you have to do it in the petition claim. So that's what we said. Then we got, in response, on the 7th of May, we received the amended petition claim. And Your Excellency will find at page 2 KWM's response. And it's fair to say that their position was that their original petition claim was sufficiently pleaded, and they put forward the amendments without prejudice to that position. But then in relation to the request for further information, they said this, at paragraph 5b. At request 4 and 5, the defendant sought details such as contractual words and conduct relied on by the claimant, which resulted in the form of the loan agreement. I think the form of the loan agreement, that's meant to say. As stated in the response, given the conversations from nearly 4 years ago, a verbatim record of the words used cannot be provided. Now, just stopping there for a moment, the rule doesn't require a party to set out a verbatim record of the words, but it does require a party to set out the key bones of the oral agreement, key elements, key words used. And then it says factual evidence of the conversations will be provided by way of witness evidence at the appropriate stage of the proceedings, i.e. that they've got further material that they could give on this, but they're not doing so now. And they say the information provided in the POC is adequate for this stage of the proceedings. Any information beyond what is provided is a matter for evidence, which will be provided by the claimant in the appropriate stage, notwithstanding the claimant to set up brief details of the formation of the loan agreement and brief details of the advances made pursuant to that loan agreement. And we responded, so that letter was a week ago, so less than 7 days before the CMC, and then we responded at page 6. And we said, essentially referring to 1741 and 1742, under the heading amended particular claim, we say the requirements of those rules are not onerous, should be easy and inexpensive for your client to provide that information, since he should be able to do so from his own recollection. If conversely, as appears to be the case, he's unable to recall any circumstances where there was an oral agreement for a loan or conduct which gave rise to an agreement for a loan, then he should say so. And then we say, at a minimum, what the rules require. Now, we had hoped that in response to that letter, the claimant would put forward a further revised draft, but the claimant's chosen not to do so. And so, in the circumstances, the court is currently faced with the claimant's amended petition claim, which I'll take you to now, which appear at tab 7. Which we say still do not comply with 1741 and 1742. And if Your Excellency turns to paragraph 5, Your Excellency will see that there's a new sentence that's been added. And I'd be grateful if Your Excellency would read that to yourself. I'm grateful. Now, Your Excellency, my learned friend referred to this as my application, but as I explained at the outset, it is in fact his application because he needs permission under 18.2 to amend his predictive claim. And as I've shown, Your Excellency, by reference to the Orion decision, the burden is on him to make sure that his claim is properly particularised. And absent that, the court does not give permission. Now, in my submission, we're suggesting today that this court requires the claimant to comply with Your Excellency's order of the 5th of April. And there's a number of reasons why we say that should happen, and that should be a condition of the claimant obtaining permission to amend. I've got three reasons that I ask Your Excellency to take that course. The first is that the court has made an order of the 5th of April, and that was not appealed, and there was no suggestion at the time that the claimant wouldn't comply with it. Court orders are not optional. That's the first point. The second point is the rules are mandatory, as I've shown Your Excellency. And the third point is it's no answer for the claimant to say that we'll have this information at a later date at witness statements. Your Excellency will note from the timetable agreed by the parties that witness statements are not until mid-July, and this matter is going to trial on the 20th of August. So if we get the particulars at that late stage, it will be too late. We say 3 points. First, if the claimant is unable to provide these particulars, we should know now. Secondly, we say that we won't be able to address the case against us in the witness statements unless we know what the case is under 1741 and 1742. And thirdly, we say compliance with those rules are particularly important because there is at least a question before the court as to whether the claimant will attend trial. Now, Your Excellency may have noticed from the case memorandum information sheet that the claimant's proposal is that he attends trial by video, not in person. Now, that is obviously very surprising for a party who wishes to rely on an agreement which he says was entered orally. But as we understand the position, my learned friend says to me, we do understand that he's been deported by his wife. We do understand that he has been deported from the UAE and that he may not be able to attend. But even if he's giving evidence by video, that is obviously not very satisfactory. And it's all the more reason why we should know at this stage precisely what the oral case is against us. Now, in light of those matters, we say that the proper course is for Your Excellency to require compliance with the rules in order for my learned friend to have permission. And if I take Your Excellency to our draft order, does Your Excellency have that? It's attached to my skeleton argument. Paragraph 1, we're content for them to have permission in the form of the draft that they've proffered, but we say there are 2 conditions. The first condition is in relation to the oral agreement agreed by contract, that they particularise that information listed. And that information listed is the same information set out in our letter of the 9th of May. And in fact, the same information that we've been seeking right the way along. It's not onerous, and we say that the appropriate course is for the court to require them to produce that. And then the other point B, over the page, relates to the claimant restitution. Now, I can deal with that very shortly, if I may. This is the only other issue on the pleading. I mentioned that the restitution claim was first introduced in the claimant's reply, and I heard what my learned friend had to say about the fact that it wasn't put forward as an answer to the claim as a gift, and I'm grateful for that clarification from him. But just in relation to adducing a new claim in a reply, RDC 1750 says that a subsequent statement of case must not contradict or be inconsistent with an earlier one. For example, a reply to a defence must not bring in a new claim. That's 1750, page 107. So with the greatest respect, it was obviously an error to introduce the restitution claim in the reply, as the claimant originally did, And the proper course, of course, was to put it in the particular claim, which they've now sought to do. We'll just have a look at that pleading, which again is at tab 7, this time paragraphs 18 to 20. And I'd be grateful if Your Excellency could read those paragraphs to yourself. That's page 4 of the pleading. Now, Your Excellency, as I understood from my learned friend's submissions, it seems a common ground between us, and no doubt my learned friend will correct me if I'm wrong, that a key element to a claim for restitution is to identify the unjust component. Because without the unjust component, there is no claim. And that's why, in fact, my learned friend uses the words unjust enrichment in the pleading, because that is the correct phrase. Now, this claim of restitution does not identify the factual basis for the claim. It doesn't identify any unjust factor. And as my learned friend seemed to accept, if this was a gift, there is no unjust factor, and the restitution claim would fail. Now, in my learned friend's skeleton argument, he has very helpfully clarified, and this was also helpfully clarified in correspondence. He says, paragraph 11 of his skeleton, the amendments in respect of the claim for restitution are premised on the particulars pleaded for the claim under the loan agreement. So, as we understand the position, he is relying on exactly the same facts and matters that he puts forward for the loan agreement case to write his case in restitution. Now, in our submission, there's a question as to whether that works legally, but that's a matter for trial, not a matter that I'm going to ask you to determine today. But it does seem to us that he should be held to that. What we don't want to find is when we get to trial, there is some new claim of restitution. So our proposal is that in granting him permission to introduce that, there is also some language inserted into the pleading to hold him to what he's already said. And the wording that I have proposed at paragraph 1b of my draft order is simply that the factual basis of the claim in restitution is premised solely on the particulars pleaded for the claim under the loan agreement set out in paragraphs 5 to 8 above. Now, we'll hear from my learned friend about whether he agrees with that. If he doesn't agree with that, that rather highlights my position, which is he ought to tell us what the basis of the case is. But I'm hopeful that that may be agreed. Now, that's paragraph 1 of my draft order. Given how long this issue, this small but crucial issue on the pleadings has been outstanding, we say that the court should put its foot down and say to the claimant either he provides this information as required under the rules in the order, or the claim doesn't continue. So we've put in at paragraph 2 an unless order. We think that's suitable and fair in the context. Then at paragraph 3, there's the standard order that the claimant pay the costs of and occasioned by the amendments. And then at paragraph 4, there's a provision for us to file our defence within 7 days of the service of their amended particulars of claim. And I know my learned friend's position in his skeleton is that we don't need to file an amended defence, but with the greatest respect, it's our submission that it's a matter for us whether we have any consequential amendments in light of what's said against us. So I at least want to have the option, even though it may be that we don't need to say very much. So, Your Excellency, those are my submissions on the pleadings. In terms of my learned friend's other points, it seems to us that the list of issues is not a point that really requires any debate. A list of issues in the case management memo are meant to be tools for the court. It's not uncommon, regrettably, for parties to encapsulate the issues in different ways. And I'm grateful for my learned friend's efforts to try and agree it. And we tried our best to put forward what we thought were sensible amendments. But it seems to us at this stage there's no value in the court having to deal with the battle of the list of issues. We should just all proceed on the basis of the pleadings. So that's that point. And then the only other point my letter friend mentioned was this factual issue about whether or not the claimant treated the first defendant as his son. That's something we've pleaded, it's something we want to rely on. At trial, we will all argue about what the consequence of that is. But that, again, isn't a matter that needs to be dealt with now. So, unless I can assist Your Excellency any further, those are my submissions on the pleading.
Thank you.
Your Excellency, thank you. I'd like to bring us back from my learned friend's very skillful submissions to the real world. The rules that define International Financial Centre Court are, of course, based on English law practice. More fundamentally, they're based on common sense and the overriding objective. A party has got the right to understand the case, but loan or money is otherwise paid over. I can show Your Excellency that even in the particulars of the claim, as originally provided, sufficient particulars have been given. What had happened is that a request for particulars was made, and because it was not responded to under the rules, that entitled the matter to come to Your Excellency on a without notice application instead of notice application. When requests for information and particulars are sought, sometimes you have arguments by both sides as to which of the requests they're entitled to have information to and which of them they're not. And the court actually applies its mind what's essential and what's not. There used to be something that we were warned as article clerks, junior lawyers, never to do at a case management or directions hearing, as it used to be called in the English courts. And that was not to consent to an order giving particulars. Because if you consented to an order giving particulars, you couldn't then serve an order saying we're not entitled to this particular. Your Excellency's order required that a response be given. In that response, my client was entitled to take points as to what information it could and would give and what information it couldn't. Now, there's no disagreement as to what the rules for common sense reasons say should be pleaded when there's an oral agreement. Now, we can have very complicated oral agreements, and then it becomes very particular, very important to set out precisely what the terms were. But this is a loan. It happened in several conversations quite a long time ago. And so what one can do, what we have done, is to do what my learned friend refers to as giving the gist. It's a gist statement. And the usual practice in English pleadings was to say the gist of the words used was this. What we have said in response is that the first defendant made all requests for the claimant for a loan, explaining the purpose of the loan was for the incorporation and establishment of the second defendant, for the purpose of opening and running a restaurant in the IFC. In response to those all requests, the claimant already agreed to advance monies from time to time as would be necessary for the incorporation and establishment of the second defendant, provided the monies would be repaid by the claimant on reasonable demand. Now, that is essentially given by way of voluntary particulars because they've known from the outset that monies were advanced. They're not disputing that monies were advanced. We say they were lent to him, but certainly were not a gift. And they say the contrary. That's all that's at issue in this case. In terms of the conduct, to the extent it is by conduct, well, they advanced the monies and demanded it back. Those particulars are given, that's pleaded. So that's the conduct that says it's not a gift. We sought to deal with this in the most efficient way, I've learned, friends, of course, quite right, that the reply is not ordinarily the place that you introduce a new claim. There's absolutely nothing stopping the court from allowing that, which then would have allowed them to put in a rejoinder without the need and expense of them amending their defence. Very simply, the court would have all of the issues before them. That's the end of it. Now, in terms of the evidence, as often happens in litigation, after disclosure is the parties' recollection as to exactly where they were. You know, were they at home in Emirates Hills, were they on holiday, etc. Disclosure brings to light things that people had forgotten. And in this day and age, it's not just emails. The fact of the matter is that we've had some discussion of electronic disclosure, and I suspect that contemporaneous evidence of what happened and when it happened may sit in WhatsApp, in Instagram, in Facebook, in whatever other nonsense is typically used these days. This is where real life happens, text messages. And then there may be evidence at trial, following disclosure, when there are witness statements. By the time the parties come with the witness statements, and my client has seen these sort of information, seen the information with respect to the second defendant as to how the money was put into the company, what circumstances suddenly the first defendant is said to have transferred his shares to his brother. You know, there will be a lot of this information that will come out, and it will go into witness evidence. But exactly where and when it happened, we've got a time frame. It's not a precise time frame, but it's 1/4 of 1 year. That tells you where you're doing your disclosure in that time frame. You've got a location. We've said Dubai. The only thing that could have been of relevance but isn't is was it Dubai in the DIFC or Dubai outside the DIFC? But since everyone is agreed that DIFC laws are applicable to these matters, that's not an issue. So there is no respect in which the defendants are at any disadvantage in certain cases. Frankly, it was only because the ball was dropped and there was no response made in relation to the request for particulars in the first place that they've been able to make so much mileage out of this. If they think that our defence, if they think that our claim is inadequate, then they've threatened in correspondence to make an application to strike it out as disclosing no reasonable cause of action. They've threatened it. They've threatened an application for security for costs. I don't think we're likely to see either of those, because the fact of the matter is there's an issue there. Was it a loan or otherwise repaired, or was it a gift? And the court will have to hear evidence and make up its mind, one way or the other. At this stage, in the case management procedure, the parties are invited to see whether, to suggest whether mediation is being considered. I can tell you that matters stand right now that on either side, the instructions are not to consider that. As a senior lawyer, I can tell you my personal view is that this is a case which cries out for someone to bang the parties' heads together to make them see some common sense, and whatever my instructions are, I'll endeavour to do that. That said, at this stage, there are all of the directions which Your Excellency is invited to give from a case management perspective are agreed, subject only to my learned friend's point. Yes, he's right, of course, that I require one of two things: either permission to serve the amended particulars claim, or an order that the claim for restitution made in reply can stand, and they can then deal with any position they may have on that as a rejoinder. And there is, and I'm sure we've no disagreement with my learned friend, only one material difference in terms of defences. The defence that it is a gift is an ending matter. There's an end of the matter if it succeeds. On the loan case, we say we're entitled to repayment on a reasonable notice. In restitution, in circumstances where we have advanced monies on the basis that we're going to get them back, the equivalent issue about what is reasonable notice comes out under a different label, and that is, has the defendant changed its position in such a way as to make it unjust for them to be required to repay that. Now, my learned friends, clients, may wish to say something on that. Frankly, the easiest way to do it would be simply to let the reply stand, introduce a new claim for restitution, and let them say whatever they want to say about that in rejoinder. It's easier, cheaper, and quicker to do it that way. The alternative is for me to be given permission to serve the amended particulars claim, and then they, of course, would be entitled to serve in defence. But that's all there is to that. Would it be helpful for me to take Your Excellency to what is agreed in terms of the order which you're being asked to make? If Your Excellency would turn to Divider 10. This is the draft case management order. It begins with the formal parts. Rather optimistically has by consent in square brackets. So what is agreed? Standard production of documents by 4 p.m. on the 28th of May. Request to produce, if any, 4 p.m. on the 4th of June. Objections, 11th of June. Where objections made, the court shall determine those objections and make any disclosure order by no later than 25th of June. Your Excellency may need to consider whether he's happy to commit the court to that. Parties to comply with the terms of any disclosure order and produce a production document statement within 7 days thereafter. It's pretty quick, isn't it? I'm told that's agreed, but frankly I would have thought 14 would be more cautious. No? Apparently, sorry, don't let me interfere with the perfectly meshed machinery that my clients, my assistants have agreed with Mr. Balla's assistants. Witness statements to be exchanged and served by 4 p.m. on the 16th of July. Reply evidence 30th of July. Unless otherwise ordered, witness statements stand as evidence in chief of the trial, so no examination in chief. Progress monitoring date 5th of August 2018. Information sheets to be served 3 clear days before, and in the event by 4 p.m. on the 30th of July. Trial bundles 2 weeks before trial. Agreed reading list. Filed with court by the claimant no later than 2 clear days before trial. Skeleton argument and chronology 3 clear days before the start of the trial. For the claimant, 2 clear days for the defendants. So they have that advantage of not being simultaneous exchange, so they get a chance to see it first. And then draft chronology to be prepared by the claimant, cross-referenced, and then by the 5th of August, comments by the 12th, chronology to be filed by the 14th, agreed if possible. And if there are areas of disagreement, there will be an agreed chronology and the chronology of defence that are disputed. respective parties' positions are outlined. Then got a trial listing window between the 20th and 30th of August, with an estimated duration of 4 days, including half day for pre-reading. Costs of the case management conference, the costs in the case, and are limited to apply. Your Excellency, I think the teams on each side have been careful to ensure that that complies with all of the requirements of the RDC. And there are, I understand, no issues or disagreements on those matters. It's simply, I mean, what would need to be added is an order either that the claim for restitution made in the claimant's reply, permission be given for that to stand as a claim, and for the defendants to serve a rejoinder by the date which I'm sure we agree. Alternatively, for us to be given permission to amend the statement.
The defendant did not agree on. You didn't agree on the amendment, yeah?
No, I'm afraid not, Your Excellency. If my learned friend is finished, perhaps I just have 3 short points to make in reply, if I may. I'm grateful for the time Your Excellency has given us. The first is that my learned friend is right, that he needs, one way or the other, he needs permission. He either needs permission under 18.2, or he needs permission to essentially breach 1750. Now, we say, in fact, it's not the right course for the court to allow in new claims in a reply. 1750 says that the court doesn't approve of that, and a reply to a defence must not bring in a new claim. So, and it explains that where new matters have come to light, the appropriate course is to seek the court's permission to amend the statement of the case. So, 1750 takes you back to 18.2. And we, in my humble submission, Your Excellency, we would be loath to drive a coaching horses through that. We say that Your Excellency has the route 18.2, and that's the appropriate course. So that's my first point. My second point is, as my learned friend helpfully elaborated, his oral agreement case is based on several conversations. He's now given us a window which is the last quarter of 2014. But we say that these particulars are still hopelessly inadequate. It is of concern that the claimant can't specify where the agreement happened. Or it said it was multiple conversations. We should at least have a proper indication of how many conversations and roughly when they took place. They should be able to put forward dates, and they really should be able to put forward locations. We say that it's remarkable that the claimant seems unable to specify where he agreed what is apparently, on his case, a very substantial loan. And it seems remarkable that he's unable to even say, well, I ended that agreement at home or at the office or wherever he was. We do need to know where it happened, who was there. That's absolutely key, so that we can make sure we've called the right witnesses to challenge any account that he may put forward. My learned friend made the point that the claimant's recollection might be jogged by disclosure. Now, that doesn't help him at all. If the claimant has no recollection now, then we need to know that. It would obviously be of concern to the court if the claimant had no recollection now, then once he sees disclosure, he suddenly says, oh, I remember. The court would want to know that, because that would go to the credibility of the claimant's account. And without wanting to trivialise my learned friend's submission, I understand a WhatsApp message might jog his memory, but I question whether an Instagram really will. And the reality is, if the claimant has no recollection of this, then he might, his memory might be populated by the evidence he later reads, but his recollection is not going to improve, and the court ought to know. So that's my second point. And then my third point, my learned friend made the point about strikeouts. Now we have said along the way that if they didn't take steps to provide an amended predictive claim, that we would apply to strikeouts. They have put forward an amended predictive claim, but one that doesn't comply with the rules. We have tried our best to be reasonable about this, and we have said, look, we're happy to consent to the amendments or happy for the court to approve the amendments, but you must comply with the judicial officer's order of the 5th of April and the information we requested in our request for further information. And that's really where we end up, Your Excellency. We say, Your Excellency's made the order, it hasn't been appealed, the rules require this, it's not a lot of information. If they can't do it because they don't know, they should say so, but we should be told one way or the other, and I would therefore encourage Your Excellency to make the order in the form of my draft.
I'm sorry, Your Excellency, just in response to one, my learned friend twice said that the order was not appealed. The order was not appealed. That would be a complete waste of the court's time for the simple reason that when a response to a request for particulars is ordered, but without there having been argument between the parties over precisely what particulars that they're entitled to, you don't appeal that order. You simply serve a response to a request for particulars saying, in certain respects, not entitled. If there's then an argument as to whether that's adequate, that then takes place. You don't appeal the case management decision or a response to a request for particulars, because in order to respond to the request for particulars that have not been consented to and not made following argument on what's entitled to and what, which sometimes happens where the court decides in advance. They look at the request, and just like a disclosure request, they say, yes, you're entitled to 1, you're entitled to 2, not entitled to 3, not entitled to 4. Then, if the response had refused to give an answer to 1 which the court said no, couldn't get the particulars, then you would be into striking out, into appealing and that. So it's a complete mischaracterisation. And again, as a young man, a friend, I've got 5 children, 1 stepdaughter. I've made many gifts and many loans to all of them, and I've never had any of them paid back because I've never asked. But if you ask me to say exactly what the conversation was, when it was, it's a testament to an honest witness who said, look, I can't recall exactly the words or exactly where it was at this distance in time. And inevitably, when there's production of documents, every honest human being is apt to have their recollection improved, and that's what the trial is for, to test the evidence. Pleadings are simply to know what's at issue, and frankly, from the start, the particulars of claim, they didn't have the additional claim for restitution, but they enabled the client, the defendant to make his case. The defendant's case is a gift. My learned friend, I will defy him to identify anything else that can be added to their defence other than it is a gift. They stand or fall on that, and that's the end of the matter.
I believe if the claimant wants to amend the particulars of claim, he should apply.
Sorry, Your Honour.
If the claimant wants to amend the particulars of claim, he can either seek the other party's consent. If the other party do not agree, then you can file an application with the courts to amend the particulars of claim.
Well, indeed, Your Excellency, it's common ground. What has happened is that we have served amended particulars, which I can take you through to show exactly why we said they're adequate, and the position of my learned friend is that he's not yet prepared to consent in their existing form, and therefore a matter for decision by you here now at the case management conference is, are we entitled to that permission? I hear what my learned friend says. He doesn't want to go off-piste by putting it in the reply, which I say would be the most efficient way of doing it, but that's fine. Therefore, I have to amend it. Now, what his objections were, I can tell you very quickly that we've dealt with them. It's common ground that RDC 1741 says that where a party relies on oral agreement, specification, set up, contractual words used, state by whom, to whom, when, where they're spoken. The request was that the words, or at least the gist. Now, this is we could have said in the amended particulars, the gist of the words spoken was. But what we have said is we've given the gist of the words spoken. Response 7, first defendant made oral requests of the claimant for a loan and read this into the record with explaining the purpose of the loans for the corporation. The second defendant for the purpose of opening a restaurant. In response to those oral requests, the claimant already agreed to advance monies from time to time as would be necessary for the incorporation and establishment of the second defendant, provided that the monies will be repaid by the claimant on reasonable demand. Now, Your Honour, Your Excellency, of course, when there's been a request for particulars and a response, then the points of claim are to be read as the points of claim as supplemented by the additional particulars. So you don't need to have an amendment for that because the particulars requested effectively form part of it.
I meant for the new claim of restitution.
The new claim for the restitution, that certainly needs permission.
Yeah, because I believe the defendant agrees on a condition which is drafted in the order. And the claimant, it's up to the claimant if he wants to agree on this condition or not. But if not, the claimant should file an application to amend particulars of claim and to add the claim of restitution. Then the defendant will respond and the court will decide whether it agrees or not.
But, Your Excellency, in terms of the efficient use of case management time, that is absolutely a classic issue for determination here and now for the case management problems.
I understand, but I don't think the defendant will agree on that.
Well, Your Excellency, sadly, litigants don't agree about everything, and therefore the function of this moment to make an order, and they will seek perhaps sources for permission to serve the particulars of claim in the form that they serve, because read together with the request, we say they're perfectly adequate, and that includes the addition of the claim of restitution, which was originally advanced in the reply. That's in the draft particulars of claim. So the only additional matter that is not referred to in the draft order put forward would simply be an order that the claimant have permission to serve to amend its particulars of claim in the form of the draft served on the defendants on, and we can put the date, and that the defendants have permission to serve an amended defence, if any, by a date which they can suggest. That's the only addition that in my respect and submission would be needed to this. And then,
So do you agree on this draft or?
yes, with that addition, this which I know the friend doesn't agree with that addition, but all of the other matters in there. Perhaps, is Your Excellency referring to
I'm referring to the defendant.
the draft order
Draft order, which is
put
case
forward by the
order
defendant?
number 2.
Well, in relation to what he's seeking, the conditions, we say, have already been fulfilled. Say, with respect to you turn over my client's position, where it says in relation to the claimant shall have permission to make his particulars claim in the form of the draft attached here 2, which is the form already served, of the conditions that he's seeking for the alleged oral agreement. We say we already have given the gist and the particulars in the amendment. And in relation to the alleged agreement by conduct, we say we've already particularised the conduct, we've paid over the money, we asked for it back. In relation to the final matter, what I think my learned friend is trying to do is trying to prevent us from saying any more about why it's unjust than we have done already. In relation to that, I think it's the sensible approach would be to provide that unless we give further particulars in relation to what we say makes it unjust within the time that it's to be served. So if we have permission to amend and serve particulars, how long we need? 17? Within 7 days. That his requirement, but the factual basis of the claim in restitution, this is really trying to tie us down, I would say, inappropriately at this stage, because new facts will emerge, and if they do emerge, one might need to make amendments, but frankly, this would be, the evidence would deal with all of the circumstances, following discovery, following people being sat down and having been interrogated. We've already said, incidentally, that the only witnesses that we intend to bring to trial are the first claimant and his assistant. So, learned friend's point, they have not said who they're going to trial.
That's why I asked for an application. Because you introduced an alternative claim for restitution, which the defendant, I believe, would agree if this condition is satisfied, which you don't agree with the condition, that will tie you. So that's why I asked the claimant if he would like to introduce an alternative claim for restitution. He should seek the court's permission by an application. And then the defendant will have the opportunity to respond and the court will decide.
So what I understand Your Excellency to be saying is that His Excellency is happy to make all of the agreed case management directions in the draft order by the claim, but they're requiring a further application to be made, for permission to be made.
First of all, you don't agree to this draft order filed by the defendant.
No.
You agree to certain points, but to the point of restitution, which is point B in paragraph 1 of the order, you said that it will tie you.
Well, no, sorry, with respect, sir, of the 3 conditions he imposes, I don't agree with 1, because it's already dealt with. I don't agree with 2, because it's already dealt with. And frankly, I resist 3 as well.
So you don't agree with the order. But you introduced, in the amended particular of claim, you introduced an alternative claim of restitution.
For which I seek permission to amend
Yes,
before you today.
but I don't have an application filed. I believe the defendant, I'll ask the defendant if they agree with this or not.
Your Excellency, my letter friend does is required to make an application, it seems to us that obviously there's the issue of the court getting its fee, and that is something that can be resolved after this hearing. But in terms of the question of whether the claimant's amended particulars of claim should simply be allowed in the form put forward now, or whether it should be allowed with the conditions that I propose, I'm content for Your Excellency to rule on that today, if Your Excellency is happy to do that. I think my learned friends, as I understand his submission, I think his point is we're all here today and able to argue the point and happy to put it in Your Excellency's hands as to the way forward. And I think my learned friend has helpfully drawn the battle lines in that he said, in relation to my draft order, that he wants essentially permission under my paragraph 1, but without any of the conditions. So, as I understand his case, he just says he should be granted. There is obviously a draft amendment particular claim. He's put that forward last week. Your Excellency can rule on that, and the only question for Your Excellency is whether or not to impose these conditions. Now, perhaps Your Excellency, I may just briefly deal with the submission from my learned friend that he has provided this information at 1A, 1 and 2, because I didn't understand him to say that earlier. And 1A, 1 and 2 are very specific and are based entirely on 1741 and 1742. And 1741 requires the party to specify the contractual words used. They've not done that. It requires the party to state by whom and to whom those words were made. That's crucial in my submission, Your Excellency, because one needs to know who was there. We need to know if there was an oral agreement.
It is clear by whom and to.
But in my submission, it's not.
Response so that the words were spoken to for claim of the first offender.
But we need to know who was there, Your Excellency, in particular in relation to the second defendant, which is a company, and so can only be represented by natural persons. There's nothing in the pleading about who was representing the second defendant, and that needs to be pleaded. This rule is a mandatory rule, and then when and where they were spoken. It's not in my submission good enough to say there were several conversations in late 2014. Parties should be specifying dates, and they should be specifying the location. And it's particularly concerning, we say, that they don't seem to be able to remember the location. So it really calls into question, in my submission, whether there is any proper factual basis for this claim at all. And Your Excellency has made an order on this, and the rules require it, and all we're asking Your Excellency to do is to hold them to the rules and what Your Excellency has ordered. And in my submission, if they are allowed to get away with pleading in such vague terms, then that will be a licence for other litigants before this court to take a very flexible approach to 1741 and 42. And I think in my submission it would be troubling for the proper running of these sorts of oral agreement and conduct cases if the court allowed them to get away with it. So we say, hold them to it. It's not difficult. They could do this in a paragraph. And if the truth is that the claimant can't remember, then he can say, I can't remember, but hopefully I might see something in disclosure which may jog my memory. But I do urge Your Excellency to make that order. As I said, it's not difficult or expensive to comply with, it just requires a paragraph.
Your Excellency, with respect, the learned friend is saying that we haven't done things that we have, right? I've read to you, not once but twice, the gist of the word spoken. It doesn't have to be much when there's a lane. Bro, can I have a fiver and go and get 2 cigarettes? That might be a loan, that might be a gift. Just as the word spoken. It says, we don't say where they were spoken, we say Dubai. Where in Dubai is utterly irrelevant to their case. There's no jurisdictional issue about DIFC Dubai. It doesn't matter if they were on the top of the Burj Khalifa or hanging by their feet from a tree. It was in Dubai. Date, day, year, we said at the end of 2014. Conduct, it says where a party relies on agreement by conduct, the state of the case, we specify the conduct relied on, and state by whom, when, and where the acts constituted the conduct done. Sorry, before that, he said, doesn't say who the words were spoken between. They were spoken between the claimant and the first defendant. That's the answer. Conduct. The response says the claimant relies on having advanced sums in excess of 14.9 million AED, paragraphs 11 and 12 of the claim, in the period November 2014 to June 2017, the first and second defendant as detailed in the attached consultant report of 30th August 2015 and court-appointed accountancy expert report, each issued and in the possession of the parties in Dubai court proceedings, etc. Following the defendant's oral request of the claimant, following the claimant's oral agreement to advance the sums requested by way of loan, the claimant made the advances, so that's the conduct, finance, and incorporation established with the second defendant. Then goes on to list, instructed the relevant banks to make the transfers, identifies the banks, provided checks for rental payments, record of the advances within the report. So, I mean, it's been fully particularised. They've requested the dates and the months, and the response is November 2014 to June 2017. The address where the acts constituting the conduct, well, they identify with respect to the transfers, National Bank of Brazil Harar branch and Mashreq Brazil Court branch. So all of those, in my respectful submission, are already dealt with, either in the amended particulars of claim themselves or in the particulars which have been given. So that's why I would say no condition should be attached, and that the only additional order required that isn't in the agreed case management directions, which I've taken your honour through. The only additional order is that the claimant be permitted to serve the amended particulars of claim, which we can attach to the order, and the date that is set for an amended defence, if any. And apart from that, all of the other directions are agreed. And that order is in tab 10, the agreed order.
So the amendment is done, yeah?
Yes. It's all done.
You're just seeking the permission of the courts?
Or the only addition, if you look at the draft case management order in tab 10.
No, I mean the particulars of the claim, sorry. In tab
Yes,
7.
Your Excellency, the draft amended particulars of claim have already been served in draft, and to identify them, they would just be appended to the case management order with permission the claimant to serve the amended particulars of claim in the form of the draft attached.
Anything else you'd like to add?
Well, my reference suggested that they complied with 101 and 2. Now, our submission that's demonstrably wrong. They have, as I said, the second defendant is a company. my learned friend said is that their case is, which is not even made clear in the pleading, that the words stated were stated by the claimant to the first defendant, haven't explained who was acting for the second defendant, who was representing it, why this second defendant is bound, haven't identified the location. In my submission, it cannot be good enough to say Dubai. It really, it denudes those words in the rule of any meaning if you can simply give the answer before this court, when the court asks where was the agreement entered, you say Dubai. That plainly cannot be what the rule requires. The rule requires a proper location and a proper specification of when it happened. Because imagine, Your Excellency, if the claim is permitted to continue in this form, when we come to do our witness statements, how do we deal with this allegation of a loan? We don't even know the dates on which the conversations were made. We don't even know who else was said to be present. We don't know who is said to be representing the second defendant.
In the cross-examination, you'll be able to find out.
Well, I know, but my very strong submission, Your Excellency, that would be an unacceptable way for a trial to be conducted, and that may well result in the adjournment of trial if new factual matters arose during the cross-examination. The whole point of pleadings is that so there should be no surprises at trial. And so a claimant who asserts an oral agreement is not permitted to keep their powder dry, to keep quiet until they've seen all the documents in disclosure, and at that point put forward their case on the facts. It's obviously a recipe for abuse, and Your Excellency should rail against it. In my submission, the rules have been put there to be complied with, and this court should say, we don't tolerate parties not complying with the letter of the rules, we require them to do so. And as I said, it's not difficult, and in my submission, Your Excellency should be troubled by the fact that they are resisting so hard on providing these basic deals. We've been here over an hour and a half, and my learned friend has given various examples of gifts that he's given to his children. There are more particulars given there of the gifts that he's given to his children that the claimant has given of this multi-million dollar loan. So that's my first point in relation to the particulars. And the second point is on the restitution. All we're looking to do is hold them to what they have said in correspondence and in their skeleton argument. And the reason for that is I don't want to find that close to trial there are new factual allegations raised for the first time which goes to the restitutionary claim and we've not had a chance to deal with. And again, that will result in an adjournment of the trial or a mistrial. And again, Your Excellency, in managing this case, will want to avoid that. The way that litigation is done for this court is cards on the table. It's about open, fair, being honest about what your position is so that the parties can properly narrow the issues. And given that approach to justice, in my submission, it's not onerous to require the claimant to comply with this order, and indeed it would be very unsatisfactory if they were allowed not to. So I would strongly encourage Your Excellency to take this course. Is there anything else I can assist Your Excellency with?
Thank you.
I'm grateful.
Then the court will issue the order to me. Yeah? I won't make an oral order, but will be issued by email today. Thank you.
Thank you.